Good evening, ladies and gentlemen. A very warm welcome to this Current Legal Problems lecture. It's really quite special in a way to have legal problems lectures happening face-to-face again after our previous year of Zoom only. So I'm particularly delighted to see so many of you here today to come and hear Roderick's lecture. My role this evening as an editor of the Current Legal Problems series is to introduce our chair for the evening. Our chair is Lord Reid. We're absolutely delighted that he's been able to come and chair the event. As I'm sure you will all know, he is currently the President of the Supreme Court. He was appointed to the court in 2012. He was Deputy President in 2018 and has been President since 2020. As I'm also sure many of you are aware, Lord Reid has been at the forefront of many of the developments and innovations on which this lecture reflects and discusses. So we think he's the perfect person to chair the event. We're very grateful to you, Lord Reid, for being able to do so. Thank you.
Well, can I add my own word of welcome? It's really wonderful to see so many members of the tort scholars community gather together in real life in front of me. And we have a great many more joining us online. I have the task, I've been entrusted with the task of translating any questions that the online audience pose using the chat function, translating those questions and giving them to Roderick. So we'll see. I mean, I'm not the most competent person with technology, so we'll see if you're quite as pleased to have me as the chair at the end of the evening as you are at the moment. As you say, I've taken an interest in tort issues on the court, so I'm particularly interested in what Professor Bagshaw will have to say. I'll try to resist the temptation to use the chair as an opportunity to get my retaliation in first. I'm looking forward very much to hearing what he has to say. Roderick Bagshaw is the Professor of Law at Oxford and a Fellow of Magdalen College, the co-author with Nick McBride of a well-known textbook on tort law, and also one of the contributors to the Practitioner's Bible, Clark and Linsell. His talk is, I'm told, is addressing the question how courts should go about deciding whether a duty of care is owed by a defendant to a claimant in particular circumstances. Obviously, crucial question. One which has been much discussed by judges and scholars for at least 100 years. So far as the judges are concerned, we'll be grateful for all the help that you can give us. Professor Bagshaw.
Thank you to Professor Paul Mitchell and the team behind Current Legal Problems for inviting me to speak this evening. And many thanks to everyone in the audience, real and virtual, for being the you that I get to speak to. And really special thanks to Lord Reid for being willing to come and chair this evening. It's one of the great privileges of academics in this jurisdiction that the judiciary so kindly give of their time to help with events like this, and I really am grateful to be the beneficiary this evening. This lecture then is about the approaches that courts use to identify whether a defendant owed a duty of care to a claimant and can therefore be held liable in the tort of negligence, provided that the other requirements, however many there are, Jamie, provided that the other requirements of the tort, the duty having been breached and that breach having caused actionable damage and that damage not being too remote and negation of possible defences being satisfied. Now, it's not, of course, the first lecture to deal with that topic. It's not even the first current legal problems lecture to discuss the topic. It may even begin in a different sister journal, recurrent legal problems. And the scale of the catalogue of previous academic writing stimulates an immediate question. Well, why hasn't the problem of identifying the optimal approach already been resolved? Or to expand, that given that the UK Supreme, given that the UK, oh dear, it sadly decided to abandon me. Oh, there we go. Given that the UK Supreme Court has exposed the mistake that there is a Caparo test which applies to all claims in the modern law of negligence, and that in consequence the court will only impose a duty of care when it considers it fair, just and reasonable to do so on the particular facts, and having exposed that mistake has reconfirmed that the whole point of Caparo was to repudiate the idea that there's a single test which can be applied in cases in order to determine whether a duty of care exists, and has instead commended an approach based in the manner characteristic of the common law on precedent and on the development of the law incrementally and by analogy with established authorities. Given that it's done that, the rollout of what we might call category-based incrementalism 2.0 seems to be still vulnerable to much the same criticisms that were directed at the first generation product in the late 1980s. Specifically, complaints like the categorization complaint, that the process for organizing precedents into categories and then deciding which features are necessary or sufficient for a duty to exist is non-transparent. So it could be a smokescreen for a judicial evaluation of public policies, or worse still, a smokescreen for unconscious intuitionism. Second complaint, that the approach, which is based on having special rules category by category, tends to preserve and amplify arbitrary distinctions. And further complaint that, well, in the absence of any overall mission, the approach provides insufficient guidance on whether a particular case is one where one ought to take an incremental step, or whether it's one where one should say this far and no further, or only Parliament can now sort out this situation. And so far as those criticisms have been reverberating through the lecture halls for 30 years, though with a special Zoom-enabled echo last year, the first challenge I've set myself is to explain an apparent double failure. A failure of the courts to dampen those criticisms, and a failure of the tort professors in England and Wales, and indeed most other common law jurisdictions, to identify any plausible alternative approach that could have resolved their own criticisms without generating equally serious objections. My second challenge tonight then is to make some progress in addressing this deficit on the law professor side of the double failure. So, first challenge, try and explain the double failure. And my explanation of it starts with two related propositions. To choose between approaches to identifying duties of care, it's necessary to decide what an approach ought to achieve, specify the task before designing the tool. But in fixing what the approach ought to achieve, we got to make sure we don't set impossible goals or combinations of goals that it's impossible to achieve simultaneously. Now, no doubt some in the audience will condemn starting with those propositions. They're banal, and frankly patronizing. You know, generations of outstanding judges and scholars have addressed the duty of care issue, and it's absurd to suggest that they were unaware of the utility of defining goals, or that they didn't realize that it was pointless to plan an expedition to capture a will-o'-the-wisp. And I agree, but this lecture isn't just for you. That this lecture is also for those fledgling law students who each year arrive in my tutorials, having read a tort textbook and maybe one or two appellate cases, but believe that the optimal approach to identifying a duty of care will be capable of determining whether such a duty is owed in any situation, and will be capable of reaching decisions that are both just and consistent with good public policy, and will be capable of being applied to a novel hypothetical situation by a law student under exam conditions after 160 hours perhaps of study. Now, those beliefs assume that an optimal approach can fulfill, I would say, an impossible combination of demands. To break it down, excluding some artificial possibilities, an approach to identifying duties of care is going to prescribe a series of intellectual tasks, and no approach is going to be able to transform those tasks into mechanistic calculations so that you can determine the answer from the input, regardless of the person who's performing the tasks. And that's going to be the case, whether those tasks are conceived of as weighing competing policy concerns, or evaluating 17 salient features, or making judgments about rights. You arrived just in time. Or assessing the persuasive power of an analogy and grading the distance between the current case and the limits drawn in previously recognized category of cases. So turning to the detail of whether it might be possible for an approach to kind of meet these demands, well, take the requirement that the outcome should be both just and consistent with good public policy. Even if we assume that there's some appropriate compromise between interpersonal justice and public policy, we assume that that compromise can be fixed. To keep them quiet, let's just concede to the rights enthusiasts that the only appropriate compromise is complete surrender of public policy. It just has to throw itself on the mercy of the Parliament. It still seems scarcely plausible that anyone thinks that the judiciary could set out a method for discerning what is just between the parties, that a law student with only 160 hours of training could apply to any situation and derive a result. If only disputes about interpersonal justice were so easy to resolve. So, at this point in the lecture, I've submitted that the judiciary have not solved a recurrent problem, and that it's all the law professors' fault because we haven't identified any plausible answers to our own criticisms, and all the law students have been entertaining impossible beliefs. The guide to delivering a current legal problems lecture that I've been consulting actually cautions against alienating your entire audience. And so I guess I should try and get some people back on side. And so the good news is, for the students who are watching online, you're not to blame for your own delusions, that they are also the fault of the law professors. That specifically, we still haven't purged the word test from our textbooks, and we haven't highlighted the essential distinction between scalar aspirations and binary goals. Our teaching of duty of care has too often been a history of negligence. And I mean that in both the ways in which it could be understood. Distinguishing between scalar aspirations and binary goals is essential to avoid the impression that we expect an optimal approach to be capable of achieving an impossible combination of things. What's the essence of the distinction? There's simply that some goals are impossible to achieve fully, but progress towards them is a scalable advantage, so that getting close is better than falling a long way short. Getting closer still is better. Think of reducing the friction between components in an engine, or reducing the cost of application of an approach to identifying a duty of care. Now, of course, recognizing that many of the goals are just scalar aspirations is just a start. A fuller analysis would have to recognize that some of those aspirations, perhaps higher predictability of outcomes or lower cost of operation, have to be assessed using scales that aren't linear. And moreover, that the achievement of scalar aspirations is usually not evenly distributed. The cost of operating an approach or the predictability of outcomes from applying it won't be constant across different types of cases. Other goals, however, aren't scalable like this, but are binary. No one wants a library ladder that will almost enable the reader to reach the books. And no one wants an approach to identifying duties of care that's going to lead to duties that defy the will of Parliament, or that's going to require judges to perform unconstitutional tasks. Respecting the will of Parliament, avoiding unconstitutional judicial behaviour are binary goals. And my accusation is that in criticising approaches for falling short of various goals, we haven't underlined how many of those goals were only ever scalar aspirations that inevitably had to be traded off against other aspirations to create a workable design. And thus, it's our fault, law professors. We've allowed our students to expect the impossible. We've implied that there are alternatives to category-based incrementalism 2.0 that could have achieved impossible things. If you want a swift illustration, well, think how frequently you've seen a case note criticize a category-based rule for using an arbitrary line, with the silent implication that category-based rules can be drawn without employing arbitrary lines. Is that possible? Well, some of you might think that question, which was meant to be on the previous slide, but somehow I skipped over one, that they might think that question, is it possible to have category-based rules that don't use arbitrary lines, asked with that intonation that indicates I thought it was a rhetorical question, is unfair. I might say, well, perhaps category-based rules inevitably use arbitrary lines, but why must approaches to identifying duties of care use category-based rules? Because the alternative approach that Professor Stapleton's recommended to judges, where to simplify, and I realize there's a risk in simplifying with her in the audience this evening, but to simplify, that judges should proceed by identifying all the valid reasons in favor of a duty and all the valid reasons against there being a duty, and then weigh those reasons against each other, accepting always that a legal system should strive to maintain consistency in its assessment of the relative significance of reasons, and should do that by looking back at previous judicial assessments of the weight of reasons, that approach doesn't use category-based rules at all. And it's an approach that gives a central role to reasons, and it emphasizes transparency as a goal. A losing litigant will be able to trace back what reasons tipped the balance against them. But in giving such a central role to reasons, it seems to sacrifice the advantages in terms of the degree of predictability and probably the speed and cost of application that might have been achieved by using techniques like expressing conditions in terms of accessible facts, those facts that it's easy to establish. Whatever one might think of the Alcock criteria, it takes very little to get law students to reach predictable, consistent, and quick answers to the question, did the claimant see a loved one being endangered? The intellectual tasks involved in assessing a situation to determine accessible facts, like did the claimant see loved one being endangered, can be performed swiftly without elaborate legal training and without much differentiation according to who's asking the question or who's answering the question. I would say that they're very different tasks from those required if you had to identify and weigh the competing reasons in support and against the recognition of a duty of care, or to assess the significance of 17 salient factors, mate, Now, whilst objections can, of course, be raised to the rule because it depends on an assessment of belovedness, the power of that objection depends on how frequently that factor actually gets disputed, relative to how frequently parties can reach consistent views on which side of the line a particular case falls. And whilst Alcock's an unusually clear example of a duty category being defined using accessible facts, it's not unique. I could make a similar point with, did the defendant indicate to the claimant that she could be relied on to perform the task in a way that was going to take care of the claimant's interests? Or did the defendant exercise control over a thing that would be very likely to injure the claimant if it wasn't properly controlled? Expressing conditions, defining categories in terms of accessible facts enhances predictability, but it reduces transparency. We can tell the claimant, pursuer in Borhill and Young, you're going to lose this case because you neither saw a loved one being endangered nor experienced events that predictably terrified you for your own physical safety. But that because doesn't introduce any explanation of why the law takes an interest in whether the claimant witnessed a loved one's endangering, why that makes a difference, why it would be different if the claimant witnessed a loved one struggling to come to terms with life-changing injuries. Now, if there's an explanation behind the rule, it may have been formulated by a rule maker at an earlier stage, but it may not exist. We can't actually go back to the House of Lords in Alcock and ask why it thought that developing a psychiatric illness as a result of watching a loved one struggle to adapt to life-changing injuries should be treated differently from developing a psychiatric injury as a result of witnessing a loved one being more suddenly endangered. And we can't go back to the House of Lords and ask it to explain why they attached significance to control in Dorset Yacht, to the advantage of the best man who gathers the gang on Brownsea Island for a Baden-Powell-themed stag weekend. That's a free exam question. That's probably enough for some of you to have come tonight. So far, though, I've only suggested that there's a tension between goals, scalar aspirations, like predictability of application, reduction in use of arbitrary lines, transparency, speed, cost of application. But to make good the accusation that law professors are implicated in their students expecting impossible things, I need to show that it's necessary for any approach to identifying duties of care to use categories and inevitably arbitrary lines. Now that's a bolder claim, because it involves claiming that Professor Stapleton's approach, which as we saw relies on reasons, not category-based rules, is a blueprint for a process that's impossible. And so I'm going to try and convince you that it's an approach that just cannot achieve consistent and predictable outcomes. Now, I've got to pause here to make something that's clear to the law students who are watching the live stream. It might look as if I'm picking on Professor Stapleton, but there's a reason. And that's because she's the most important tort scholar in the room, both metaphorically and really. It's a close run thing tonight, but that's the reason, in a sense, why I'm focused on her. That when I started off, 25 minutes ago, with the claim that tort professors hadn't identified any alternative that could meet their criticisms, well, she was the person with the best reason by far for finding that offensive, because her writings have taught other tort scholars, me included, though perhaps I didn't learn quite enough, so much about the factors that properly and improperly influence judicial decisions about duty of care. So if it looks as if I'm picking on Professor Stapleton, that's because I actually have to neutralize her approach to make any progress at all with my claim that approaches that don't use arbitrary lines are roadmaps for impossible journeys. It's not just me that needs this, that the judiciary probably need it too, because they stuck with category-based incrementalism without providing a means of neutralizing the criticisms that people like Professor Stapleton had provided. So if there was a plausible alternative available, that's a choice that would need defending. If there was no plausible alternative, the alternatives were impossible, much better off. So, big moment. Can I convince you that Professor Stapleton's approach, which relies transparently, ever more reliably on reasons, involves a process that just cannot achieve consistent and predictable outcomes? To cut to the chase, my claim is that it cannot achieve predictable and consistent outcomes because our best assessments of the weight of several pivotal reasons are insufficient to determine which claims should succeed. Shall I do that one again? It's a key sentence, so perhaps I should do it again. So that our best assessments of the weight of several of the pivotal reasons that we want to rely on are simply insufficient. Knowing how much these reasons are weighing is insufficient to determine which claims should succeed. So you want an example? Well, suppose that we accept the argument that there's a good reason not to allocate immediately all the foreseeable psychiatric costs of road accidents to negligent drivers. That the price of motorists' liability insurance influences consumers' spending on other items. It influences how many people can lawfully drive. It influences how many will be tempted to drive uninsured. And the advantages of providing private psychiatric treatment for those who are going to struggle to overcome their grief and the like just isn't going to be enough advantages to overcome the disadvantages of a sudden sharp rise in premiums. Some of you might be content to label that type of argument a Floodgates argument. Now, there's plenty of unconvincing Floodgates arguments about, but that doesn't establish that such arguments can never bear rational weight. Even the most puritanical adherents of a rights-based account of the tort of negligence accept that the law doesn't have to provide a corrective justice mechanism for every interpersonal moral right. There's scope for a judgment as to whether mirroring particular moral rights in tort law might do more harm than good, that there's scope in legal policy for decisions about appropriate rates of legal change. But the difficulty I want to use my Floodgates argument to illustrate is that the reasons that it summarizes cannot determine the optimal definition of the privileged group whose claims we can afford. So even if we all agree that the best assessment of the weight of that argument is that currently our society can only afford to attribute 40% of the psychiatric costs of motor accidents to negligent drivers, that's not enough to tell us which 40% of victims should be helped by tort law. Would it be better to relax the sudden shock requirement, but maybe tighten the relationship rules? Maybe relax the relationship rules, but curtail the length of an aftermath? Rebalance the law in favor of long-term carers ahead of those that suffer sudden shocks? The Floodgates arguments simply cannot tell us which 40% should be prioritized. And justice arguments aren't going to fill the gap. And if we turn to goals like consistency and predictability, we find a directionality issue. We can influence consistency and predictability of outcomes by the choice we make as to which 40% to privilege, particularly if we express that choice in terms of accessible facts. But the consistency and predictability come from expressing the conditions in terms of accessible facts, not from agreement about the rational weight of the argument that justifies drawing the limit. And I don't believe that that feature, that the rational weight of the reason is insufficient to determine who should be owed a duty and who should not, is a peculiar feature of Floodgates arguments. If you want a second clue, it's in tort law legislation. Tort law legislation is, well, I don't want to say always, but let's say always, framed in terms of facts: occupier, visitor, premises, producer, consumer, product. It's not framed in terms of reasons, and there's a reason for that. Well, that was the big moment, but of course, for some people, they might think it wasn't the big moment. It might be that those who favour a rights-based approach think they're being neglected this evening. Perhaps they even think that I've made a mistake by attaching so much importance to Professor Stapleton's views, because it's their rights-based approach that's the most plausible alternative to category-based incrementalism. And that all those concerns about whether general reasons can determine which groups win can easily just be sidestepped by prohibiting any judicial attention to general reasons. All that matters is whether the claim is based on a general right that the claimant could establish against the defendant. In response, I'm willing to concede that the primary objection to a rights-based approach is not that it falls short on predictability of outcomes. The primary objection is that all too predictably, it sacrifices concern to protect the vulnerable and most other societal goals in favour of a bizarre preoccupation with internal coherence. More pertinently, however, the notion that a rights-based view can achieve a satisfactory level of predictability without translating judgments about rights into slightly arbitrary accessible facts strikes me as highly optimistic. Things like increasing diversity of knowledge mean that even simple moral concepts like reasonable foreseeability can't be applied consistently and predictably without being translated into slightly arbitrary accessible facts. That is, into rules that effectively stipulate harm is reasonably foreseeable in that factual situation and not in that one. Indeed, readers returning to Alcock may be surprised to see how far Lord Keith's speech is actually expressed as assertions about what is reasonably foreseeable and what is not. That, in my opinion, simply appealing to reasonable foreseeability when you have such differences in society as to what people know about when behaviour will affect others psychologically, just isn't going to give you consistent and predictable lines. Well, at this point, I should turn to improvements, because that's what the title advertised. And depending on whether you were convinced by the last 20 minutes, I'm either going to be sketching improvements to a possible approach to identifying duties, or to the possible approach to identifying duties, or perhaps just as usefully, I'm going to be unintentionally establishing that there's no hope of rescuing category-based incrementalism from its critics. Earlier in the lecture, I introduced some criticisms, and the three most reverberative criticisms, we can review them. The categorization complaint, the arbitrariness complaint, the overall mission complaint. And in the final 10 minutes of me speaking, I'm going to try and sketch some possible improvements to address those criticisms. But to hear that 10 minutes, you're going to have to overlook my hypocrisy, because I haven't provided you with a comprehensive account of the goals that an improved approach to identifying duties of care ought to be pursuing, let alone divided that account between those goals that are binary and those goals that are scalar. That said, that the guide to delivering a current legal problems lecture that I've been using recommends leaving the listeners wanting more. And it doesn't positively forbid this by shortchanging them. So until the written version appears, I'm just going to ask you to accept that an improved approach ought to pursue at least scalar aspirations of justice, predictability of application, low cost of application, transparency, and advancement of legitimate social goals, plus a binary goal of constitutionality. So improvements to meet the categorization complaint, first of all. So that's the complaint that the process of dividing cases into categories and identifying within each category, well, what are the features of the situation that are either sufficient or necessary to establish the duty, or which, if present, will be sufficient to mean that there can't be a duty, that process is non-transparent, that it's not really clear how it is performed. The main difficulty with proposing any improvement to address that complaint is that the complaint is primarily related to what happened in the past. to the qualities of the decisions that have already been made, the precedents. That once a court has decided a key precedent without making clear what features of the situation were necessary or sufficient for the duty that it recognized, or how broad the category was intended to be, well, the current approach faces a challenge in addressing that shortfall. That, of course, the fact that the categorization complaint is a consequence of the state in which past judges have left the law means that we have to be cautious not to exaggerate the force of the complaint. In some categories, the past judges may have left the cases in a good condition for category-based development, but in some situations they may not have done. So what improvements can we suggest there? Well, one improvement would be to highlight to those deciding current cases means of reducing the frequency with which the categorization complaint will be made in the future. If the gains by way of predictability that future lawyers will enjoy depend on the categories being made today using things like accessible facts, then current judges should respond to that future need. The academic response to category-based incrementalism 2.0 has tended to equate it with the ordinary method of judicial reasoning that's adopted both inside and outside tort law. It's a quotation from Winfield and Jolovitz, which obviously everybody in the room knows off by heart. But I'd suggest, though, that deciding duty of care cases so that the decisions provide a good foundation for future category-based reasoning is distinct from ordinary judicial reasoning. The distinction can be illuminated by thinking about a balance between doing justice between the parties and legislating for future parties. And that if one's trying to decide cases that will be suitable for category-based reasoning in the future, the balance is moved towards legislating for future parties away from attention on what's just between the current parties. That, of course, is also reflected in what one can do about effectively messy historical precedents. When one's dealing with messy historical precedents, that one could seek to unearth a ratio decidendi. Alternatively, one could seek to unearth a suitable rule for category-based reasoning from. And I don't think those two things are the same. Well, those are some suggestions with regard to the categorization complaint. You only get 8 minutes worth of improvement, so you have to keep going. That the arbitrariness complaint, that earlier on in the lecture, I obviously suggested that some degree of arbitrariness is inevitable in an approach based on category-based rules that uses accessible facts in order to secure a good degree of predictability. And the accessible facts that are best suited for incorporation into easy-to-use rules simply may not correspond precisely to the boundaries that would become evident if we were to decide cases using a direct appeal to the reasons. Indeed, I went further and I claimed that some of the reasons that we may want to take into account can only be given effect by being crystallized into arbitrary lines. That said, there is a prominent subfield of the arbitrariness complaint that merits attention. And that's a problem that arises in particular where a past court identifies the features of a frequently occurring situation that are necessary to establish a duty of care. And then a subsequent court assumes that those same features are necessary outside the frequently occurring situation, but are actually general, universally required across a far broader field of cases. That an example of this is perhaps provided by the secondary victim psychiatric injury rules, that they appear to have been decided focusing on a particular frequent situation where the accident occurs, it's witnessed by the secondary victim immediately. Rules are set down about witnessing the accident, immediate aftermath to the person, that sufficient relationship of love and affection. Problem then arises if you get a group of cases which don't meet the frequently occurring factual pattern. For instance, the defendant's negligence has a delayed effect on the primary victim. Perhaps the negligence causes what appears to be a minor injury, but that injury later gets worse and causes the primary victim to collapse 6 months later in a way that causes trauma to the relatives. Now, regrettably, courts using a category-based approach seem to run into problems with these cases, seem to get excited about, oh, well, when was the accident that you had to perceive? Was it the first accident where they got the minor injury, or was it the worsening? Can you have a 6-month or sort of accident with a gap in the middle? And it's because they're using a rule that's been developed for a frequently occurring pattern of facts much more broadly. That how one deals with that problem is, I don't think, straightforward. But I would suggest that one aspect of it, or aspect of the problem, is that we have a current assumption that a category should be capable of being formulated using a single catalogue of mandatory requirements, and that's unhelpful. It would be better to perhaps think of the typical category as consisting of a cluster of cousin situations, rather than the more Procrustean, there has to be a single definition that all the cases in the category fits approach. But this is perhaps most easily illustrated by thinking about assumption of responsibility. That I think some other Oxford professor stood up and gave a current legal problems lecture on assumption of responsibility and followed a pattern that's frequently seen in academics of saying assumption of responsibility, there has to be a recipe for it, one single recipe. You know, what's the recipe? Is it promise? Is it anticipated reliance? What is it? If the cases don't fit a single recipe, there must be a problem with assumption of responsibility. My suggestion is, well, maybe assumption of responsibility is a cluster of cousin categories rather than a single recipe. Maybe it's more like cake than like Coca-Cola. The last improvement that I have to make is with regard to the overall mission complaint. And here I've got no improvement to propose, and that's not simply because I've already exhausted all my ideas and probably your tolerance and almost certainly the time available, but because I think this complaint should be celebrated. There is no overall mission statement that can explain why it was appropriate to extend a duty of care to the parents who were devastated by the choice they'd been misled into making in W and Essex, and to the girl who was protected less well than her classmates in Woodland and Essex, and to the purchasers who lost their life savings in Smith and Eric Bush, and to the daughters who lost their modest inheritance in White and Jones. But the lack of a single inspiring phrase to unify all these situations where an extended duty of care can be recognised shouldn't be seen as a failing, shouldn't be seen as a basis for criticism, but as a consequence of the vitality of the tort of negligence as a Swiss Army knife tort. Now, I may be employed by the institution that taught Lord Atkin classics, but standing at UCL, it's obviously more appropriate to quote Lord Macmillan. The categories of negligence are never closed. There will always be a possibility of extending them further, cautiously and incrementally, and perhaps using a modestly improved approach. But that possibility of negligence being extended further to meet whatever new varieties of injustice the future holds is something that I think we ought to celebrate.
Well, a number of gauntlets have been thrown down to puritanical rights-based scholars, to unrealistic policy-based reasoning scholars, and no doubt others. So I'm sure there must be some comments or questions. Yes, Jane Stapleton.
Roderick, what puzzled me was that in going through your ideas, you didn't refer to Lord Reid's approach set out in Robinson. Because as I see it, my approach is actually quite consistent with Roderick. And that is, it's a precedent-based incrementalism. And when you are inviting the Supreme Court to depart from precedent, the Supreme Court balances reasons for and reasons against. So I think these actually should go together. And since he's sitting next to you, this, Lord Reid, I'm not really trying to deflect the fire onto you, but I am interested in hearing Roderick's views on your approach.
Yes. I've been told that for the benefit of the cameras, I should repeat the questions. So I'll try and because I've got a microphone and you haven't. So I'll try and get the gist of it. Professor Stapleton's commenting that Robinson itself is consistent with her approach, because her approach is essentially based on precedent-based incrementalism. And that when the Supreme Court is considering a hard case and whether to develop or depart from a precedent, it does go through a balancing process of the competing reasons. And so she suggests her approach can, in fact, go together with the in shorthand, the Robinson approach, and is asking for Professor Bagshaw's response. I may have my own response as well.
Well, I mean, fantastic question. I think one of the difficulties with the question is about proportions. What proportion of cases get decided using the category-based approach, and what proportion of cases get into the open discussion of public policy? And the answer to that might vary according to which level in legal processes we're dealing with. Are we dealing with proportions in the Supreme Court, or are we dealing with proportions in the lawyer's office where you went for some advice? And so for me, the approach to identifying duty of care is not really a set of rules that the Supreme Court laid down for their own self-discipline to tell themselves how to decide cases, because they have far more freedom and far more time, and frankly, a lot's been spent on these cases already. And so designing an approach that gives you a high level of predictability and consistency and can be cheaply operationalized is much less important once a case has reached the Supreme Court than it was long in the past. And so if I was to ask myself the question, who is an approach to identifying duties of care for, then I'm not sure that I would start with the Supreme Court. And there's an odd paradox here that, you know, if an approach that's category-based really works, you don't see it because it solves the case before you get a dispute that a judge has to resolve. For me, though, the sort of the notion that the approach, the Robinson approach is clearly a 2.0 product. It's a much improved product from the previous one. That doesn't sound, well, probably does sound patronizing. It wasn't intended to be patronizing. It's a much improved product, but I'm not sure that the improvements answer the category-based, answer the categorization complaint that you made so forcefully in your writing, Professor Stapleton. The complaint that basically was to the effect that it's not clear from the precedents what the pivotal facts are here, which facts are necessary, which facts are sufficient. And so far as it's not clear, but it needs to be clear in order to work from the category that there's a non-transparent moment where suddenly, once there was a dispute, the judge announces, no, it's clear, these are the facts that you need. And I don't think the 2.0 product provides an answer to that criticism, that it might provide an answer to what you do in truly novel cases, if and when we see them, and it certainly provides an answer to what you do if you want to encourage a revision of categories. But I'm not sure it provides an answer to what I saw as the core of the category complaint, which is it just isn't determined by the precedents what the key facts are too frequently. That was a long answer. I'm going to have to do better. Shorter answers next time.
Yes, in the middle. Jane Steele. Yes.
So I'm trying to work out whether you think we're failing or not, because many of the things that you said seem to imply that actually we're not really failing, we're just unable to label very clearly in advance in a way that a law student would find it easy to understand in the abstract. But when it comes, if you were to set a problem question or something like that for a law student, under what circumstances would they really not know where to start with the discussion? Would they really, under what circumstances would it really be very different from the statutes you refer to, which refer to facts? You can't write a problem question without facts, and you can't have a case without what we call facts. So are we in fact in a position where most people would know, even after a few hours studied, as I say, what kind of arguments we're going to need to resolve the case, i.e. incrementalism seems to fit what you're saying. So are we failing, really, is my question.
If I can again just repeat that for the online audience, Professor Jenny Steele is asking whether the academic community is actually failing, although scholars may be unable to label situations in advance. Under what circumstances would even students really not know where to start and what arguments to consider in order to arrive at the right answer?
I mean, again, a fantastic question, and it's really difficult. Those on the live stream, you can't see the audience. I've got this incredibly, terrifyingly learned audience in front of me, and what I haven't got in front of me is the less good tort lawyers who perhaps write the lazier case notes that make the complaints that I'm making more pertinent, and you can't see who I've got in front of me. So it's difficult for when I get asked by Professor Steele, are we failing? That's a much harder question than if she was asking it on behalf of everybody who's ever published something on tort law. Then I perhaps give a different answer. Where I think I would put it is take a case, the Michael and South Wales case. You got a split in the Supreme Court. You've got a majority that take, I would say, a pretty straight category-based approach. Say there's two exceptions, doesn't fall in either of the exceptions. We're not going to extend the exceptions. End of case. There's a minority that take a much more fluid approach. And I would say most of the students that I teach prefer the minority. That they simply, they probably prefer it because of the outcome, but they also prefer it, they think, because of the reasoning. And so I'm kind of with you, Jenny, that many of our students would be able to operationalize a category-based approach and would know how to use it to answer an exam problem, but actually they would prefer not to. That they would prefer to use a much looser approach, and they seem very comfortable answering exam problems where they say, first I'm going to assess if there's any proximity. I have a look, yes there is. And so, there are symptoms that there might be patches of failure. if students have those sorts of reactions that they want to prefer the looser approaches. Yeah, so that's, I guess, where I'm coming from. I've obviously just taught too many students who have particular traits.
Robert Stevens.
Thank you for Roderick. My question is, what do you think a duty is in private law? I think a duty in private law is an obligation owed to somebody else to do something. And that's what an obligation is. And so some of these cases, they're about duties. So these cases about the police and whether or not they are a duty to individuals to try and protect them from being beaten up by villains. That's a duty question. To which the answer is no, they don't. They're in the same duties as everybody else unless the statute says something to the contrary. The statute doesn't say anything to the contrary, that's it. Cases are correct. Those are duty cases. But a different question is whether or not it would be a good thing if this defendant in these kinds of cases should be held liable. So you have liability questions. And Alcott, for me, has nothing to do with the duty of care. Did the police owe a duty not to go around causing recognised psychiatric injuries to these people, foreseeably? Well, of course it bloody did. I mean, it's ludicrous to say that it shouldn't have been careful in relation to these people whose lives they've trashed. So the question then is a different one. It's about, should we be allowing all these people to sue? Should we put limits on liability? And that's a liability question. And then they say, okay, we've got to control the liability, you've got to fit these categories. And that's where your line drawing, for me, comes in. If you think that's a good idea, you've got to engage in that. But that, for me, has nothing to do with the duty of care. The duty of care is just about whether A is B an obligation, and that's usually dead easy. Anyway, that's my question. What is a duty for you?
Yes. I'm sorry. No. I'd better. I'm not sure I'm up to the task. I certainly can't match the verve of the question. But in a nutshell, Professor Stevens is pursuing, I think, a familiar line of argument from his work, which is that there's a distinction between duties, i.e. obligations, and deciding whether it's appropriate for an obligation to exist, and on the other hand, liabilities and the desirable limits of liability, and Alcock is an example of the latter.
Okay. I think I just don't buy the distinction. I don't think you've got a clean distinction. And I suspect you just, if I was being crude, that you just put cases on either side of it at convenience, according to whether you want to accept them as fitting with your coherent duty model or having to be explained in some different way, whether they go on the liability side of the line. And so, I'm afraid I don't buy the distinction. I mean, because the real distinction between us is that I'm quite happy for judges to develop incoherent duties when it does some good. And if, just like I'm quite happy that, legislators making criminal law should create criminal offences that don't actually fit with the rest of the criminal offences if the new one does some good. And so for me, I've got no concern that we might be telling people, hey, you actually have got a duty to look after somebody here, even though it's only going to be some slightly arbitrarily defined group that are subject to such a duty. And I actually have no problem with the opposite, with telling a particular group, actually, you can live your lives without worrying about this person's interests. You don't owe a duty to look after their interests, or at least particular types of their interests. I'm really happy with that being a duty statement rather than a liability statement. But I think this is just because we start from different starting points as how important it is that it all hangs together in this coherent way. For me, if somebody says, you like living in England, yes, and you like the private law of England, I say, yeah, I quite like the private law of England, and they say that's because it's so coherent. I'd say, no, that's not quite it. That's not my main goal in making law and enforcing it against other people. I've got other objectives that I'd put first.
I think we've time for one more question, and James Goudkamp has had his hand up for a while.
Thank you very much. My question is stated compactly is whether or not category-based incrementalism, as you term it, is in a privileged position. Let me try and explain a little bit what I mean by that. Is you presented these different options as alternatives as though they're on the same plane. So we've got Professor Stapleton's possibility. We've got the category-based incrementalism, rights-based approach. It seems to me, though, that they may not really be alternatives. I think that incrementalism is in a privileged position because it's essentially, the way I read the case, is ordinary judicial reasoning and application of precedent. And by virtue of the law's authority, it has a preferential position over any of the other alternatives that are available. Sure, the other alternatives, there might be things that could be said in favour of them, and maybe objections to incrementalism. But it seems to me that, to some extent, it's impervious to certain objections because the law has accepted the system of precedent within which we live.
Yes, James Goudkamp is making a point which bears some similarity to the point that James Stapleton made earlier, suggesting that incrementalism as recommended in Robinson is simply ordinary judicial reasoning. That's how lawyers reason, and because of the status of precedent and the approach to precedent in a common law system, that methodology is in a preferential position as compared with alternatives.
So it's a great question. So if I got to try and prove that there's a difference between ordinary decision-making and category-based incrementalism, I need a test, don't I? I need a test that's going to either prove the null hypothesis or the like. And I think the test is the ratio decidendi test, which I think I'm taking this from Professor Stapleton. The ratio decidendi of a case, is what? It's the rule that was necessary to the decision. Well, was it necessary to state a rule that would apply across a whole category? And so, for me, the ordinary judicial approach of, it's the ratio decidendi that's binding. Well, no, here the rule applies across a whole category. That's what's different. Now that has real consequences. Say we're thinking about striking out cases as unarguable. How close to the precedent does the case have to be in order to get struck out? And for me, the scope of what's taken to have been decided is broader than what one might think had been decided using an ordinary ratio decidendi approach. Now, of course, it may be that areas other than duty of care and negligence, we find these different scopes of ratio decidendi as well. But for me, that actually the benefits of category-based reasoning, that you can dispose of cases that strike out, that you can give advice to a whole swathe of claimants, that you just can't bring claims like this, are benefits that actually come from that effectively extended precedental effect of category-based decisions. Yeah, that's not quite a litmus test, though, is it? But that would be, in a sense, the test zone that I would invite investigation of to try and prove that these decisions have a broader precedential effect than one would normally expect from ratio decidendi thinking.
Perhaps I could finish by making a few comments of my own. I often have the feeling that law is too difficult for most lawyers, and indeed it's too difficult for most judges. And appellate judging is a pragmatic activity, And the degree of sophistication that's appropriate to the analysis rather depends on the nature of the subject matter. Now, if we're talking about law of negligence, a judge like me would bear in mind that 99% of cases are settled by negotiation between solicitors, and virtually all the rest are decided by the county court, with junior counsel appearing. The proportion that get into the higher courts is tiny. So you're not in the same realm as commercial law, tax law, for example, company law. And in that context, there's a lot to be said for rules that are expressed in simple language, which allow for quite complex judgments to be made unconsciously, but trusting in the good sense of the people who actually have to make these decisions. There's a famous story about Lord Mansfield, who had a friend who was going off to the colonies, I think to be a governor, and as such had judicial functions. And Mansfield told him, never give reasons, because your decisions will almost always be right, but your reasons will always be wrong. And there's something about that in relation to tort, and a sort of formula like reasonable foreseeability is it's so open-ended that it allows a great margin for a county court judge, for example, to make an assessment which will almost certainly be right, without having to go through the sort of analysis which a chancery judge might undertake in a complex tax case. And I mean, even in the Supreme Court, we sometimes have to do this. We had a case recently which raised a completely novel question, and most of us felt that we weren't in a position to devise, let alone agree on, a general theory and then apply it to the facts. We were all agreed as to what the proper outcome was on the facts. And so we decided the appeal on that basis, but expressed our reasons in very open-ended language, realizing that we weren't giving prescriptive guidance, but we were allowing the law to be developed in later cases. I don't myself think that what's suggested in Robinson is categorization. Categorization, I think, is something mainly done by academic scholars in textbooks. And in practice, a practitioner will turn to Winfield and Jolowitz or Clark and Linsell or whatever it is, and find a set of principles set out under a heading like, I don't know, professional negligence, surveyors. Then there'll be a section for bankers, a section for architects or whatever, and you find the cases collected and some analysis of them. But that sort of approach isn't really the way that if the case were to come to an appellate court, one would look at it. One would be looking at the precedents, and in the usual way, with any precedent-based analysis, you're trying to decide whether the current case is analogous, is sufficiently akin to be decided in the same way. I mean, you use the expression cousins, and I think there is a sort of family relationship. I mean, or are the differences material so that a different outcome should result? And the materiality obviously depends on what you called traditionally is called a ratio decidendi. I find that a very untransparent expression. And I personally think that one is thinking, well, what were the reasons that led the court to decide that case in the way it did? And are there features of the present case which would justify taking a different view? I think it is rather akin to Jane Stapleton's thinking. As you've made clear, there's a limit to the extent to which one can analyse these things. To some extent, you have to rely on intuitions about judgment, about what's fair. Equally, when we're trying to think about reasons for taking one view or another, unless we're lucky enough to have something like a Law Commission report in which there's been a body of evidence considered with responses from insurance companies, professional associations, and the like, the assessment has to be much broader than that and more amateurish, frankly. And that's one of the reasons why I'm cautious about adopting an explicitly policy-based approach. But you are trying as best you can to think of, what are the reasons for distinguishing or following, on the other hand, the precedent and deciding it and considering that this case falls within its ambit or not. Now, I'm not going to invite questions or comments on that. Well, this has been a great pleasure this evening. Really grateful to Roderick Bagshaw for giving us a stimulating lecture. It provoked a lot of questions. I sometimes have a nightmare where I'm appearing inadequately prepared before the bench. I never have nightmares about being a judge, but I have recurrent dreams about my time at the bar. I think the nightmare for somebody in an academic position as a tort scholar is to appear before such a constellation of tort scholars. Professor Bagshaw has done very well, and very grateful to him.